Good day, welcome to Macklaw. Rian van Wyk here, jurist and legal enthusiast, and today we'll be discussing driving under the influence. It's a very and particularly serious offence given the fact that over the last festive season we've got horrific reports of accidents that led to fatalities because of people negligently and irresponsibly getting behind a wheel while under the influence of alcohol. Now, South Africans, especially us as Cape Townians, we love partying. It's the party capital of the world. And no one is saying, let's not party. The government or the law is certainly not saying, stop partying and stop enjoying partying and stop having whatever beverage or alcoholic beverage, whatever you enjoy while partying. You know, that is what we do and that's what we love. We're a friendly party city. However, no advantage or nothing good comes without its disadvantages. We can't party and have a great time and then irresponsibly get behind a wheel and risk our lives, other road users, as well as even pedestrians. So that's the reason for our show today. Now, in an effort to curb people from transgressing against drinking and driving, the cabinet has reshuffled laws and they purport to, or intend to rather, to change the minimum sentence for convicted drunken drivers on our roads to a minimum of 2 years. And they want to push up the schedule or the category that the offence goes from a Schedule 1 to a Schedule 5 or a Schedule 6 even. Now that is the same category or the degree of heinousness as murder or rape under certain severe circumstances. And unfortunately, this is my take on the matter. I believe it is a sincere effort from the government or from the cabinet, but I believe it's a futile effort because our conviction rates for drunken drivers are somewhere between 1 and 5%. So if we're talking about upping the sentence, are we really going to be deterring people from drinking and driving if only maximum of 5% of drunk drivers are getting convicted? I believe absolutely not. And why it's so easy to get acquitted of a drunk driving charge is because, as we always know, the state has to prove its case beyond a reasonable doubt. A trial, or an accused person's trial, has to be speedy and therefore making it fair. So now there's a massive backlog of blood samples at our pathology laboratories where the blood alcohol level is actually tested, and without that vial of blood or that report, which is expert evidence coming to court to make the state's case or to at least give the state a prima facie case to actually institute prosecution against you, there is no case. And now in our Criminal Procedures Act in section 174, it states that if at the end of the state's case they have not proved a prima facie case against the accused, then the court has to acquit. But now, imagine at the beginning of the state's case, there is no prima facie evidence. The state has no option but to withdraw. And that is the reason why our conviction rate is so low when it comes to driving under the influence charges. And that in itself will put the state in a precarious position when hiring or upping the minimum sentence for driving under the influence as an aid in curbing offenders from drinking and driving. So it seems like throwing out the baby before the bathwater. So with that being said, that's Macklaw for this week. Catch us next week where we'll be discussing more controversial legal topics. And guys, we here at Macklaw and Mackworld do not support drinking and driving at all. So what was said here from a legal defensive perspective is not to encourage people to break the law and contravene the laws that's supposed to keep us safe. So stay dry behind the steering wheel, and if you want to party it up, be responsible. Take an Uber.